I can confirm that we all have our panelists on board, except for Ms. JB Gonza, and that the webinar is being recorded. I think it is time that we now allow Fida Chepkurui to say an opening prayer. Fida, over to you.
Good evening, everyone. Welcome to today's webinar. And I'm going to start off with a word of prayer. So let us pray. Dear Almighty and loving God, we glorify and thank your name. You have showered us with so much blessing, and your presence continuously reminds us of your faithfulness and guidance. Today we ask for your guidance, support, and wisdom as we begin this discussion. Shower the members of the panel as well as the moderator with your great inspiration, O Lord. Father, we also pray that you bless all in charge of Jumuiya as well as the organizers of the webinar, so that they may be able to achieve all the objectives they've set. We pray all this trusting and believing in your holy name. Amen.
And thank you so much, Fida. We can now have the Jumuiya anthem play.
Mungu twaomba uilinde Jumuiya Afrika Mashariki, tuwezeshe kuishi kwa amani, tutimize na malengo yetu. Jumuiya yetu sote tuilinde, tuwajibike, tuimarike, umoja wetu ni nguzo yetu, idumu jumuiya yetu.
It appears we lost Melissa, or the person who was playing the Jumuiya anthem. I will then just proceed once again on behalf of our Dean, Professor John Osogambani, and our Editor-in-Chief, Dr. Harrison Bori, members of the editorial board, members of the advisory board. It is my pleasure to welcome you to the 4th edition of our webinars in our Jumuiya webinar series. This webinar is organized by the Jumuiya East African Community Law Journal. This journal is a peer-reviewed periodical of Kabrak University School of Law, whose aim is to offer scholars and practitioners of EAC law a platform to produce and disseminate their research. To this end, I would like to notify us that there is a call for papers under the theme marking 25 years of the treaty establishing the EAC. That call for papers is out. I encourage you to submit your work for publishing into our 2nd volume of the journal. The deadline for submitting short commentaries or reviews is 30th of June, the year 2024. I also wish to note that the journal, Jumuiya East African Community Law Journal, runs a blog known as Usuli, which welcomes contributions anytime on any subject relating to the East African community. You can also find us on our Twitter handle For purposes of this webinar and throughout the webinar, please use the Q&A function to submit your questions, which questions will be relayed to our panelists at the right time. At this juncture, I now want to welcome Mr. Donald Dare as advocate to then begin engaging with our panelists. Welcome, Don Dare.
Thank you very much, Edmond, and good afternoon to all colleagues in East Africa, and good morning to those that I know are joining from other parts of the world. We are very privileged to have you here with us. We do not take lightly that you've taken your time to join us on a busy afternoon. There's at least 58 of you present, apart from the organizers and the panelists, and we appreciate that. Before going much further, I would like to recognize the dignified presence in the plenary, the Honorable Mr. Justice Nestor Kayobera, President of the East African Court of Justice. Thank you very much, President, for joining us. And also the Honorable Ms. Martha Wangare Karua, Senior Counsel of the Courts of Kenya and former Minister in the Government of Kenya. The Honorable Justice Dr. Henry Peter Adonyo, Judge of the High Court of Uganda, and also Her Worship, Ms. Christine Mutimura Wekesa, Deputy Registrar and indeed Acting Registrar of the East African Court of Justice. We thank you for joining us and apologies for any other dignitary that I may have overlooked. I would also like to take this opportunity to just congratulate and acknowledge our colleagues from Kabarak University School of Law for the work they're doing around the Jumuiya and ensuring that they and with Pan-Africanism from a rigorous academic and scholarly platform, but also one that engages the public in a dialogue. It is important that we participate robustly as citizens in all arms of our government at national level, regional level, continental level, and beyond. And for that, we thank you for the work that you're doing. Without further ado, I just point out that it is good as part of public participation in the entire cycle of the judicial arm of government to engage prior, during litigation, post-litigation, both in implementation where the decisions are capable need to be implemented, but also in interrogating our judiciary, because the judiciary is accountable by the jurisprudence, the decisions that it makes. And in that regard, I am very, very glad that we have with us 4 of our esteemed colleagues. One may not have joined, but she was supposed to speak later on. And that is Professor Frederick Edward Ssempebwa, founding and senior partner of Katende, Ssempebwa and Company Advocates, and amongst other things, President Emeritus of the East Africa Law Society during one of its most phenomenal phases. Ssempebwa was actually counsel in the famous at the East African Court of Justice. We also have with us Dr. Owiso Owiso, an international lawyer, a scholar, researcher, and consultant who has published a lot on public international law. We have with us my colleague in the office, Ms. Esther Muigai-Mnaro, advocate, and also program manager in the office of the CEO of PALU. And then we'll also have our colleague, Dr. Ms. J. Gonza, acting secretary to the council of the University of Dodoma. So without further ado, and in that order, I would like to invite the panelists, starting by Professor Ssempebwa, to make their opening remarks. We have requested the panelists to make their opening remarks maximum 10 minutes so that it gives us enough time to have an interactive debate with all the colleagues who have joined. So over to you, Professor Ssempebwa.
Thank you very much, Don. It's a long time we haven't met. Am I heard? Do you hear me?
Yes, you are. Yes, you are very clearly.
Okay. It's a long time we haven't met. I hope Arusha is okay. I'd like to congratulate you for what you've been doing at PALU and particularly at EACJ regarding the reference out of which the controversy has risen. I have read the reference which you argued, the Martha Karua reference, and also the opinion of the Supreme Court of Kenya. And I would like to make just a general comment of what has been bedeviling us in this region. We entered into a treaty, 3 gentlemen then as our leaders, and they signed a treaty under which I hope they understood that the essence of regional trade, which was the basis of the original basis of integration, required us to pool our resources, our powers and functions for effective regional trade. And that meant actually establishing a power base, a new power base at the region in order to oversee what had been undertaken under the treaty. And this power base must be regarded as a distinct power base separate from the power bases of the member states or the partner states, as we call them, East Africa. However, it's been a real struggle and is ongoing for us to realize that we have now a separate power base at the region, and we want to maintain the power bases at the state level as if this power base had not been established. So there is a problem about respecting this regional power base, and it's not something that is unique to East Africa. It has happened in other regional integration schemes. If you look at the European Union, and particularly the member state being Britain, it went in, but it wanted to maintain its insularity. And they were always lamenting about this new power base at the union level. And with regard to the court, if many of you perhaps have read the history of the conflict between the European court and the English court. So the English judges, and in particular our idol, Lord Denning, were always lamenting about the loss of their powers to the Union Court, the ECJ. And eventually, if you look at the causes of Brexit, it's not because Britain was not gaining economically, but basically because they wanted to maintain their insularity, to maintain their power, to maintain the judiciary. They were particularly perturbed that their constitutional principle, which they favored much, the supremacy of parliament, was now being subjected to the European Union. So when you see the controversy that has arisen, you can clearly discern this problem that we are still reluctant to recognize that there is a new power base. Before we go into the nitty-gritty of the case itself. I think this is a problem that pervades our integration and something that we have addressed. That we cannot, I don't know the English say, but we cannot keep our sovereignty 100% when we have created new power bases at the region that are necessary for achieving our integration agenda. So I wanted to make this general comment at the beginning. Maybe I'll come in later. Thank you.
Thank you very much, Prof. And again, those were nice and brief, opening remarks that helps to set the tone. Swiftly to Dr. Owiso Owiso. Doc, we also invite you to make your opening remarks before we open up to interactive discussion. Welcome.
Thank you, Don, and thank you everyone else who has managed to put this together. And it's always very interesting listening to Professor Ssempebwa, people who've done a lot of work to get this system up and running, even as the rest of us criticize it a lot. But we thank you for all the work that you and your generation have done to actually get us here. We are basically standing on your shoulders. So just in terms of opening remarks, what I would say first, reading the Supreme Court of Kenya's advisory opinion, I have quite a number of issues with that particular advisory opinion, but of course we will get into that in the substantive discussion. But just as a way of introductory observations, I think what appears to me reading that advisory opinion is two courts that have decided to fight each other, to play supremacy battles, a supremacy battle which is entirely unnecessary. And why I say entirely unnecessary, because my understanding of the jurisdiction of the two courts is that they have both exclusive domains of the jurisdiction and concurrent domains of the jurisdiction, which are, in my opinion at least, very clearly delineated in the EAC Treaty. So this supremacy battle that we see here is not particularly very necessary. And I'm reminded of a conversation I had with Professor James Muigai, and from that conversation it emerged to me, at least, that what we are seeing is some sort of nostalgia, first on the part of the East African Court of Justice itself, where the court is struggling quite a bit to appear as if it has the same authority as the defunct East African Court of Appeal. And we do understand that these were different courts established through different mechanisms, one being a Court of Appeal of the East African, a Court of Appeal, and this other one being an international court of the East African community. So I get the sense of a court that is struggling to define its jurisdiction as an international court, but still belabored by the nostalgia of what was once a court that had what I would call an omnipotent and omnipresent court, which had the authority to lord it over all domestic courts. Then on the other hand, I see a domestic court, and this is I don't believe that this is something unique to the Supreme Court of Kenya alone. I believe we are going to see a bit of this from other domestic courts. So we see a domestic system that is also a bit, not necessarily scared, but has an institutional memory of how domestic courts interacted with the previous East African Court of Appeal, and is therefore reacting, sort of a knee-jerk reaction to what it considers as overreach by the East African Court of Justice, right? So we see a tussle that, to me, in the end, if, as one of our very good friends, Joshua Malidzo-Nyawa, says, if these judicial institutions, be they the domestic ones, being the Supreme Court of Kenya and the East African Court of Justice, if only they had a bit of judicial humility to acknowledge that our respective jurisdictions, as defined in the EAC Treaty, that is for the EACJ, and in the Constitution of Kenya for the Supreme Court of Kenya, if they were to have a bit of judicial humility and appreciate that their jurisdictions are already expressly codified in their respective instruments, and take a bit of time to read and appreciate the extent and the limits of their jurisdiction, they would realize that at the end of the day, there really is nothing to fight over, because the jurisdiction of the East African Court, a proper appreciation and understanding of it, would reveal that that particular court's jurisdiction is restricted to interpretation and application of the EAC Treaty. And while it also has, while that jurisdiction extends, of course, to interpretation and of the acts of the state, including judgments of domestic courts, that is only to the extent that this affects the interpretation and application of the EAC Treaty. I think I'll discuss that later on during the discussion. And on the other hand, if only our Supreme Court or our domestic courts would appreciate that, yes, the East African Court of Justice has jurisdiction to review acts of the state, including domestic judgments, but this only extends as far as those domestic acts of the state, including judgments, touch on interpretation of the EAC Treaty. If there's an appreciation between the two courts of this particular well and expressly delineated jurisdiction, then we wouldn't have, the problem that we are seeing today. So maybe I'll conclude my remarks there for now, and then maybe later on I'll expound on what exactly I mean by the different concurrent and concurrent exclusive domains of both courts. Back to you, Don. Thank you.
Thank you very much, Owiso, also for keeping it brief and laying out your premises. I think already the dynamic or the different approaches between yourselves will have a vibrant debate. As we go ahead again, let me just recognize the presence among us of the Dean of the School of Law at Kabarak University, Dr. John Osogwambani, and also the Registrar Emeritus of the East African Court of Justice, the Honorable Mr. Euphnalis Ndege-Okubo, who joined us shortly after we started. With that, I hand over the floor to you, Esther Wanjiru Muigai-Mnaro.
Thank you, Don, and thank you everyone who's joined, and thank you to Kabarak Law for putting this together. I'll also keep it very brief, but for me, I think the first thing that I would say as I make my opening remarks is that I'm extremely happy that the EACJ is making decisions that are making people and states uncomfortable. It means that the decisions that they are making are having an impact. As they say, you don't throw stones at fruitless trees. So I would say we are on the right track. Professor had said something important. The background at which the EAC was set and how it was established has changed in terms of how many states now we have. And that brings us to the question of, is it time to also amend the treaty, that we also incorporate all these other changes that have come in, and we also incorporate the needs of other citizens from other countries that have joined the EAC since its establishment, but we can get into that later. To go on to the decision, as I read this decision, I struggled with understanding, the reasoning behind what the Supreme Court was saying. And as we delve into the discussion again, we'll move into this, because the issues that had been put before the national courts, and I'm not calling them the municipal courts because I know in a lot of the discussions I've had, people think when you call them municipal courts, like you're saying they are down. So I would call them national courts. So the issues that had been tabled before national courts in Kenya and the issues that had been tabled before the EACJ in the Martha Karua case were extremely different and called for different interpretation. And they were not touching on the jurisdiction. The EACJ was not touching on the jurisdiction of the Kenyan courts and vice versa. So I don't understand the reasoning before the Supreme Court. And again, we will go into that when we start the discussion. I would say the flexing that the Supreme Court has decided to do has the potential of setting a very bad precedent. And this could create chaos and open avenues for other states to take the same stand. And they can say, look, As long as a decision has been made by the highest courts in our state, then the EACJ cannot interrogate that decision, even if the same is not in line with the EAC treaty. And it is why it is important for this to be discussed and for the record to be set straight on where is the jurisdiction of the EACJ and where the jurisdiction of the National Court. We cannot dare close the doors that the EACJ is opening to the citizens of the East African community. Don, I'll stop there.
Wow. Thank you very much, Esther. My panelists today are quite amazing in terms of the brevity of the opening remarks, but I think that kind of helps us get to a situation where we democratize the conversation, as I'd like to say. From what I can see, Dr. Ms. J.B. Gonza has not joined us, has she?
No, don't. She's unable to join. May want to.
Okay, all right. So I think we can now begin opening the floor. I hadn't really prepared any preconceived questions for the panelists. I thought that we'd have enough scholars, both scholars of law, scholars of economics, of sociology, of regional integration generally, to hamper their time. So as I open up the floor, I ask one general question that is quite, I want to be provocative with that question. I want to be provocative with that question because one of the things that I often say, not just in the work we do around the RECs, as you know, as PALU, we do work across the continent with the African Union, with the African Development Bank, African Legal Support Facility, and across the RECs. And I seem to sense some attitude amongst those that lead us, and not just political leaders, also bureaucratic leaders, and sometimes even leaders in the private sector and in civil society. So my question is this: would the Supreme Court of Kenya have issued if this controversy arose out of a decision of the International Court of Justice or of the International Tribunal on the Law of the Sea, or even of the International Center for the Settlement of Investment Disputes? Would we have seen this vitriol? Would we have seen these words? Would we have seen this arrogating to itself the sole responsibility for merits interpretations of national constitutional and national laws? I throw that open to the panelists. As they do that, I think colleagues that may want to speak, please raise your hands so that the host can then, admit you, and we can then get to you in terms of the question or even the comment you want to make. So panelists, what do you think of my question?
Maybe I can start, Don. And I can tell for certain, no, they would not have done so. We have a tendency of looking down on other African institutions and thinking that institutions that are outside Africa, whatever they are saying is right, or we can't question that. When it comes to our own institutions, then we think maybe they don't have the authority to do so. So I am absolutely sure if it was coming from another international court, they would not have done the same thing. And it's rather unfortunate.
Okay.
If I may jump in, Don, the answer to your question, at least my answer to that question, I'm tempted to say no, they wouldn't have, but I hesitate to say that. The reason why I hesitate to say that is that the argument's both ways. And first, yes, it's as Muigai-Mnaro says, there's a tendency for our domestic courts to privilege other international courts at the global level as opposed to international courts at the regional level, and have a bit more deference to them. That is not that I wouldn't dispute that, but I think it's important to appreciate that the advisory opinion that the Supreme Court of Kenya issued there was a context to it, and a much broader context to it. And it's important to appreciate that particular context. And what do I mean by this context? This arises out of a context where we have, as I mentioned earlier, there's of course that nostalgia from the East African Court of Appeal and the paranoia by domestic courts. But most specifically, the East African Court has also itself sort of opened itself up to the possibility of interestingly absurd, if I use that word very cautiously. It has also opened itself up to very absurd reactions from domestic courts, such as the one we saw. And why do I say that? I'm one of those people who actually believe, and I know this you know, the horse already left the stable on this one, as whatever terminology they use, but I'm one of those people who actually believe that the East African Court of Justice has been too ambitious in its interpretation of its own jurisdiction. And it has done so. It has been wrong in the way it has interpreted its jurisdiction. And it was wrong. Let's go back to Katabazi, for instance. I do firmly believe that the East African Court of Justice stretched its interpretation of jurisdiction, and it has since held on to that particular interpretation. And as I always say, consistency and persistence does not make a wrong interpretation right. Just because you say it so many times does not make it right. So going on from then, why I say that is my understanding of the jurisdiction of the East African Court of Justice from Articles 23, 27, 30, and 32 of the treaty is that its jurisdiction is expressly limited to the interpretation and application of the EACJ treaty. This, of course, extends if you read Article 31. Of course, these should all be read together. Of course, Article 31 then opens up the court's jurisdiction to review of acts of the state, which includes act of all, unity, principle of unity of the state, act of all organs of the state. But even in that particular review, that jurisdiction would be limited to reviewing act of the state, including judgments of domestic courts, only in as far as they relate to the interpretation and application of the EACJ treaty. But what has the EACJ done instead? The EACJ has indeed gone ahead, including, I believe, in the BAT case, to interpret that particular Article 30 to mean that it has jurisdiction, merit review jurisdiction over any act of the state, including all judgments, irrespective of whether it has anything to do with interpretation and application of the EACJ treaty. And that is where I depart with the EACJ. So then that to me is the context in which we see the Supreme Court of the Republic of Kenya reacting in a very knee-jerk sort of way to this particular court. That is not me blaming the East African Court of Justice. That is just me advocating for proper appreciation of the limits of that court's jurisdiction. And that is how then we end up with the Supreme Court that then also in reacting to the EACJ's expansive interpretation of its jurisdiction, the Supreme Court itself also decides to get it wrong by reading the treaty partially. There's so many issues I have with that Supreme Court advisory opinion. First, of course, because the Supreme Court says it has no jurisdiction to interpret the East African Court, the EAC treaty, then goes ahead to actually do exactly that. They say we don't have jurisdiction to interpret the treaty, then it goes ahead and interprets that treaty. Then interprets it wrongly by reading Articles 23, 27, and then forgetting that there's Article 30. So in that respect, of course, the Supreme Court would, in my opinion, would have determined that the EACJ has jurisdiction, merit review jurisdiction of domestic judgments, but only to the extent that those judgments have something to do with the interpretation and application of the EAC treaty. So the long and short of this is that there's a possibility, of course, that the Supreme Court wouldn't have touched something that concerned the ICJ or ITLOS or ISDS, for instance, or the ICC. In fact, we have a judgment from the High Court of Kenya concerning the ICC back in the day when Omar el-Bashir was visiting us. And it was a very positive decision because of the sort of respect and deference that domestic courts sort of have for global level international courts. So perhaps it wouldn't have been the case that the Supreme Court wouldn't have touched ICJ decisions, for instance, and sort of shows a bit of not much deference or respect for the EACJ for the EACJ. But then we also need to appreciate that there was a context to this. The Supreme Court didn't just wake up and issue an advisory opinion, which to my mind is very poorly reasoned, but it didn't just wake up one morning and issue an advisory opinion out of context. And I beg to stop there. I think I've ranted on for quite a bit. Back to you, Don.
Yeah, thank you very much, Doc. That was
Don,
actually
if I may
quite
come
useful.
in.
Yes, Prof. Yes, Prof. Come right in.
Yes, I've listened to the previous speaker. There is a considerable truth in what he's saying. However, the regional court has always been very clear on these matters, that they don't have an appellate jurisdiction. And that has come up in a number of cases. However, as the previous speaker said, that didn't mean that they couldn't look at a national law where interpretation of the treaty requires, and probably that is where there's a possibility of some friction. Some time ago, I was making a presentation to the EACJ judges in Bujumbura, and I mentioned that the court should be cautious on matters that impinge on the constitutional setup in the nations, in the partner states. And the case I cited was the Baranzira case, which arose from Burundi, where I thought that the court had gone a little bit far in really elaborating and prescribing a constitutional structure for a nation. But that didn't mean that I disagreed with Baranzira, but I thought that it could have caused problems. Unfortunately, Burundi didn't react in the same manner as Kenya has done. They went ahead and changed their laws in accordance to what the ECJ had recommended. So in this case, I think the troubling point is about the constitutional structure and the interpretation of the constitution of Kenya. When I read this decision, I wondered whether the Supreme Court, in fact, I didn't see the Supreme Court deciding in what manner the East African Court of Justice had exercised an appellate jurisdiction. I saw this opinion being general, considering or stating that these are the powers of the East African Court of Justice, and these are the powers of the Supreme Court of Kenya and the national courts. They should have gone into the details of how this reference actually indulged in a merit review of the decisions of Kenya. I'm still troubled about this, but I think we can continue, we'll discuss it. I stand to be advised whether I misread the opinion, but I would have been happy to see a part of the opinion stating that because, as you recall, this was one of the objections at the reference point for the East African Court of Justice, that Martha Karua was coming up with a disguised appeal. And the Supreme Court should have said in what way this was a disguised appeal. But let's continue the discussion.
Thank you very much, Prof. I recognize two members of the plenary who have had their hands raised, and I will invite them in the order in which they're listed, the order just seems to have shifted. So can we start with the Honorable Martha Karua, Senior Counsel, and then we'll come to you, Comrade Odero Oderos. So Martha Karua, SC, you have the floor.
Thank you. I'll be brief, and my comment relates to the context that in the case in which the Attorney General of Kenya was seeking an advisory from the Supreme Court, I had sued the Kenya government complaining that the judicial arm of the state, namely the Supreme Court, had failed to adhere to the rule of law principle. So that was the subject matter of the case at the East African Court. Therefore, when the Supreme Court comes under the guise of the advisory and sort of says the EACJ cannot touch such a matter, in a way, they are indulging in self-defense. It's a self-serving. So I just wanted to lay the basis that they were giving advisory in a case in which they were the main characters. And the Attorney General, in appearing, was actually defending them as the representative of the state. So to that extent, it's a very awkward matter, and I am hoping, I'm hoping to hear the panelists say something about it and say what would have been expected of them, because the EACJ had to look at the Constitution, to look at the allegations we put forward that the rule of law was not followed, and especially the right to hearing. They had no option but to open the Kenyan Constitution and read it, and their verdict relates to the right of access to justice insofar as it's part of the rule of law principle. That is where the friction is coming from. The fact that the advisory comes 2 years later, after the appeal was heard in the EACJ, is also curious. And then I want to raise one other point, that for a nation to sign a treaty, this is a political act. They negotiate, and on the advice of the Attorney General, they sign. Likewise, if Kenya is unhappy with the EACJ treaty, withdrawal from the treaty is also a political action. And that is what I believe Kenya should do, not to try and delegitimize the EACJ. That's all that I wanted to state. Thank you.
Thank you very much, Honorable Martha Karua, SC, and over to you, Oderos.
Yes, thank you, Mr. Dare. I am Mr. Odero from Civic and Legal Aid Organization based in Arusha, Tanzania. Yes, I would like to know from the panelists the mandate and the jurisdiction of the EACJ. Is it a domestic court or it is a regional court? And the second one, do the rulings and the judgment delivered by EACJ are academic exercise or ceremonial opinions? And the third one, I would like to bring to you a good news from Civic and Legal Aid Organization. We are preparing peaceful demonstration to pressurize partner state to provide funding to EACJ. This following the notice from the EACJ to disconnect or to discontinue with their normal schedules. Thank you, Mr. Dare.
Thank you very much, Odero, for that. I also note, oh, sorry, you wanted to say something more? Or are you okay? Okay. Yeah, so thank you very much for that, Mr. Oderos. I'm going to, in a second, one of the panelists, again, in any order, if they'd like to give further remarks or perspectives on any of the two presentations, especially to answer the very prescient question about Oderos, that what was the role of EACJ? Was it meant to be a court to issue academic decisions or so on? But even as I do that, I noticed two colleagues who have put questions in Q&A, and I'd also like to invite you if perhaps you want to verbalize your questions. And that is our colleague Annington Amor, former CEO of the East African Law Society, and also that advocate of the High Court of Kenya who's done quite some constitutional litigation. So maybe you might want to verbalize your questions because we have time, but otherwise we've noticed them. I see Justin has also just put in a question, Justin Semuyaba, maybe raise your hand and speak. But meanwhile, I throw it back to the panelists if you have any perspectives on any of the issues raised by the two colleagues.
Well done.
Let's start with you, Prof. Yes, let's start with you, Prof. Yeah.
A question from Mr. Odero. I don't see any controversy about this. The court is a regional court with a specific jurisdiction. And I think that's not in controversy. The jurisdiction is to interpret the treaty. The South African Court of Appeal was actually a domestic court. It wasn't a regional court. It was a court of appeal for each of the states, 3 states. And this is why it was possible for a state to withdraw jurisdiction. And the first withdrawal was by Nyerere. They said the East African Court of Appeal shall have no jurisdiction on treason matters because they had a treason trial there, and they feared that people convicted would appeal to the Court of Appeal. So those who are celebrating the East African Court of Appeal, I'm surprised because they don't know the actual jurisdiction. Of course, it was useful because it came up with good jurisprudence on matters of equivalent East African law. But that was it. So this court is different from the East African Court of Appeal. And if I may add, the national courts could differ from the East African Court of Appeal on certain matters if the state if the partner state of those courts indicated that they wouldn't obey the decisions. In this case, it's impossible, except that with this opinion now, it's possible for Kenya to disobey the decisions of the East African Court of Justice simply by observing that this arose out of a merit review of the decision of the Kenyan court. So that's the beauty about the regional court, East African Court of Justice. And I don't see any controversy except that has arisen in respect of Kenya. Otherwise, both courts have agreed that they have separate jurisdictions, and there is no appellate jurisdiction at Arusha. Neither should there be an interference by the national courts in decisions of the East African Court of Justice, which concerns interpretation of the treaty. So what we may have to interrogate in this case, did the East African Court of Justice exceed its own jurisdiction? Did it go beyond interpretation of the treaty? I think this is what we have to discuss. Thank you.
Don, can I come in?
Yes, Shiro.
I had Odero's question, and just to add on to what Prof has said. In interpretation, in the EACJ, in interpreting the EAC Treaty, it also has the mandate to interrogate and to inquire into the provisions of municipal constitutions, municipal laws, and to examine their consistency with the EAC law. Because if a decision comes and the argument is, look, it was in line with one of our municipal laws, then it is upon the EACJ to look into this national stroke municipal law, then put it vis-a-vis what the EAC treaty is providing and see, is it in line or is it not in line? And this is not unique only to the EACJ. All other international courts and tribunals do the same. And the EACJ has done this consistently. It did so in the Burundi journalist case. It did so in the EACSOF appeal. I saw the Supreme Court quoted the EACSOF reference, but then somehow ignored that there was a decision that arose in the EACSOF appeal. So I would say there's no confusion whatsoever. It is just the Supreme Court chose to pick what they feel suits them and decided to turn this to look like an appeal. It was not a disguised appeal. As Honorable Mother, my senior, clearly said, the issues that had been brought before the EACJ were only asking the EACJ to look into the EAC treaty and see if there was a violation of her rights to access to justice. And that is exactly what the EACJ did. It did not go back to what the decisions of the municipal courts had said and decided, no, Mother is going to be the governor of Kirinyaga, because that is not what she was asking before the EACJ, but that is what she had been asking for in the municipal courts. She was asking the court to look into the EAC treaty and what the EAC treaty provides. So there's no confusion whatsoever on the jurisdiction. It's just the court deciding to flex its muscles.
Thank you very much. And even if you, as you step in Owiso, I like it, Esther, that you have brought out one element, which is one of the things that intrigued me about that decision, that the advisory opinion, that the Honorable Supreme Court of Kenya, the Honorable Supreme Court of Kenya wakes up and cites a decision of the first instance division of the EACJ, when that decision had actually been overturned on appeal by the appellate division of EACJ, and this was very much in the public domain. Anyway, having said that, and I recognize the hands of Dudley, of Justin, of Huntington, but let's hear Dr. Owiso Owiso first. Doc, it's over to you.
Thank you, Don, and I've heard the comments of my fellow panelists, and I do agree with quite a number of them to some extent, yes. And just to start with Odero's question, well, at least to my mind, the first question is pretty clear to me. The East African Court of Justice is an international court that is organized at a regional level through a multilateral treaty, being the EAC Treaty. So to that, at least to my mind, that is pretty clear. But the question he posed as to whether judgments of the EACJ are merely academic, I wouldn't necessarily say so, but I wouldn't disagree either, because I've also struggled with that question. So should we be content with jurisprudence that only appeals to our valid, legitimate human rights sensibilities, or but are probably not legally sound in the sense of the material jurisdiction of the mechanism issuing them? And the question again of what use that would be, of what use this particular jurisprudence would be, if international law stakeholders, including partner states, scholars, doubt the legitimacy of those decisions. And additionally, what relevance would they be if the would-be beneficiaries cannot, source benefits and dividends from them? We have a live case here of Honorable Karua, Senior Counsel, who has developed jurisprudence at the EACJ level. Thank you very much, my senior. But the reality of it is that we haven't seen much in terms of benefits and dividends from that particular decision for the litigants in that particular respect. And that is the case with many of the EACJ's decisions. And it's not unique to the EACJ itself. This is something that plagues many international courts. But then the reason why that concerns me, so EACJ judgments are not academic. They're very important jurisprudence, and they help shape our EAC and in terms of integration and every other thing that is envisioned under the treaty. They're very important also for the general development of international law. But there is a risk, at least according to me, there is a risk that these decisions will just remain fancy jurisprudence that we academics study and lawyers quote and cite in the submissions elsewhere, but we will not get any tangible benefits from them. And the reason why I say that, I go back to my initial statement, that there is a misapprehension by the East African Court of Justice and by domestic courts, particularly in this case, the Supreme Court of the Republic of Kenya. There is a misapprehension by these particular courts of the specific jurisdiction at both levels of the East African Court of Justice. The EACJ has failed to appreciate the extent and the limits of its own jurisdiction under Articles 27, 33, all the jurisdictional provisions under the EACJ. And similarly, domestic courts, such as the Supreme Court of Kenya, for instance, have also failed to appreciate the nature and extent and scope of their own jurisdiction and that of the EACJ. So then we end up in a situation where we have a tug of war between the EACJ and domestic courts, and that waters down the sort of jurisprudence that is coming out of the EACJ. There's very good jurisprudence there, that if we appreciate it properly, it could actually help build and take our EAC, Jumuiya, to the next frontier. But if we have a situation where the EACJ and domestic courts are failing to appreciate the concurrent and exclusive jurisdictions of the EACJ, then we go back, we end up in a situation where Odero asks a very legitimate question of what then is the relevance of these judgments, of the jurisprudence of the EACJ? Is it just academic? So to me, that question, the answer to that question revolves around how we appreciate the jurisdiction of the EACJ. And just to sum up, my position as to the jurisdiction of the East African Court of Justice is that yes, it has the mandate of interpretation and application of the EAC Treaty. And that includes the mandate to conduct a merit review of domestic acts, acts of the state. And acts of the state here include judgments of domestic courts. But that jurisdiction only extends in as far as those decisions, those acts of the state, touch on the interpretation and application of the EAC Treaty. If they do not have anything to do with the EAC Treaty, then the East African Court of Justice does not have jurisdiction whatsoever in that particular context. But the EACJ doesn't believe that. It believes that its jurisdiction is omnipotent, it's omnipresent, it has jurisdiction to review literally anything, regardless of the fact that it has nothing to do with the EACJ Treaty. So everything to me around the EACJ and domestic courts hangs around this particular question of what exactly are the limits of the EACJ's jurisdiction. And that is how we end up with the Supreme Court of the Republic of Kenya issuing an advisory opinion that does not make a lot of sense. And I mean, did they even have jurisdiction to issue that advisory opinion? I don't think they did, but they went ahead and issued it anyway. So if you don't have jurisdiction to issue something, then you go ahead and issue it anyway. At least the least you could do is to give us a solid reasoning, such that even if I or Don disagrees with your conclusion, at least we see where you're coming from. But reading that advisory opinion, it is extremely incoherent. It is incoherent, it's internally inconsistent, there's very little reasoning in it. And how do we get here? We get here because the EACJ has failed to lead on the question of jurisdiction by attempting to usurp authority that it does not have, therefore resulting in a backlash from domestic courts that are not well equipped to even give a proper reasoning of their own advisory opinions. So I share the concern of Odero, but I do hope that going forward, we adopt some judicial humility, step back a little bit and start asking ourselves where the rain started beating us as the EACJ, because the EACJ is a very important court for EAC. And if we do have a stake as citizens of the East African Court of Justice to assist the court to course correct, so that we do not end up throwing out the baby with the bathwater. Thank you, Don.
Thanks, Owiso. And I'll get back to you on that point. I want to zero in with you on the point you make around the court is only entitled, the East African Court of Justice is only entitled to interrogate on a merit basis decisions of organs of state, including the judicial organ of state at the national level, so long as it is circumscribed within the treaty. I get that. In the treaty, do the partner states make commitments, make obligations, measurable obligations on issues of access to justice? I want you to think about that and answer that. Do the treaty parties make obligations, commitments and obligations on even the wider issue, democratic governance, constitutional governance? If we go back again and give a plain reading of Article 6D, where they even raise the standard, they show you the standard they will follow, they incorporate and they import the African Charter on Human and People's Rights. What does that mean? That importation of the African Charter on Human and People's Rights into the treaty, and the partner states said they will abide by it. What does that mean? What part of their governance have they left out? So as you think about that, let's welcome the colleagues whose hands have been up, starting with John Dudley Ochielo Diambo, Esquire, then followed by Hannington, and then Justin Semuyaba. In that order, Dudley?
Thank you so much, Don. I argued this case, so I do not want to appear like I'm making the arguments I failed to make in court, but I have a question for Dr. Owiso. He says that it's the EACJ which is acting from a sense of nostalgia from when we used to have the former East Africa Court of Appeal. But I wish to inquire from him which of the EACJ cases he feels did not concern the interpretation or application of the EAC Treaty, and therefore the EACJ did not have jurisdiction over them. Is it IACSOF? Is it the Burundian case? Is it Martha Karua main case or Martha Karua appeal case? Number two, this newfound Supreme Court rule, does it only exempt the Supreme Court of Kenya, or does it as well exempt the High Court, exempt the Court of Appeal, and exempt the Magistrates Court? If today a magistrate says that, corruption is prevalent in Kenya, of corruption suspects is therefore legitimate as a way of fastening these trials, would the EACJ have jurisdiction over that question? Thank you so much.
Thank you, Dudley. Hannington, you seem to have lost your mic. Is it on? If not, admin, while you try and sort out, yeah, it's there. Don? Hannington, go ahead. Go ahead.
Thank you. Thank you so much, Don. And thank you, PALU and Kabarak University, for this timely discourse. I think we've lost a lot of opportunity to interrogate where we are with, judicial approaches to the regional integration. Thank you for the opportunity today. I just have two observations, one of them being a question that I addressed on the chat, but I'll raise it again. Looking at how appointment of judges to the court happen, we've questioned this in the past decade, whether we are meeting the standard prescribed in the treaty. My own thoughts are that the Supreme Court judges of Kenya look at the composition of the EACJ and they think these are people junior to them in the pecking order and in judicial ranks. And I say that alive to the fact that the Kenyan judges at the court, none of them is at the Supreme Court judges level. They are at the High Court or Court of Appeal. And going by the recent proposal of appointment, which is challenged in court, some could be even at magistracy level. So it's expected that the Supreme Court judges would think, why would people who are not at our level in terms of experience, in terms of qualification, be reviewing and overturning our decision? So I would think other countries in the EAC partner states could actually follow this bad example and could start thinking that they could also offer such advisory opinions with a view to escaping from the harsh effects of the decisions of the EACJ. My own prescription, and the question is to the panelists, could we resolve this by having stringent, adherence to the qualifications, to the merits of appointment to the court? Could we subject this to an open, transparent process? So at the end of the day, the judges who appear at EACJ, the judges who preside over the cases, everybody has confidence in them, including our own judicial officers. The second one would be an observation. I've heard keenly, I listened keenly to Dr. Owiso, and there's a statement he has made that EACJ has usurped jurisdiction of the local courts. It would be quite in order, a scholar of his stature, to probably just cite one such instance of a decision by EACJ, which is patently an usurpation of the role or jurisdiction of municipal courts, and whether that has been corrected at the appellate level or not. My own thoughts on the matter is that EACJ at the moment has restrained and has not fully gone out to exercise its jurisdiction. Recent jurisprudence from the court actually shows that the court is shying away from exercising its jurisdiction. Article 6D is greatly watered down. We are no longer seeing the principles. The judges are simply saying, if it's not a hardcore treaty issue, we will not allow you to bring it under Article 6D, which is quite strange, looking at how long and how expansive Article 6D is. And when you look at how the treaty is drafted, there is no single municipal issue that cannot find its way in the treaty, as long as it's under Article 6D, meaning there's virtually nothing that can go on within the partner states where governments are involved, a government agency is involved, or a government organ is involved in decision-making that cannot be subjected to review by the court. That is the reality that we must get accustomed to, that while EACJ is an internal court, it's an international court with jurisdiction to check inwardly what organs and agents of the partner states are doing, and giving access to the citizens to go beyond what their courts could do. And we must also understand the context of the treaty, that some partner states in the EAC do not have independent judiciary in their own countries. Actually, majority do not allow. Judiciaries exist there as agents of the executive, and EACJ exists to reign on judicial tyranny. So I would really be happy, as I am also researching on EACJ, to just get any one decision from Dr. Owiso or any colleague in the room who might have come across a decision which went overboard beyond the provisions of the treaty. Thank you.
Thank you very much, Anton. And I think the questions that you are asking now, because now an interactive debate, it's not only for the panelists, but it's for us all. So if any of the other speakers will take the floor after this, want to interact with or engage any of the points made by the panelists or made by the plenary, feel welcome to do so. With that, I invite Justin Ssempebwa, and I also acknowledge that waiting in line are Michelle Akinyi and Emmanuel Sebijo. Welcome, Comrade Justin.
Thank you, Mr. Donde, and thank you, the presenters. Thank you, all other participants, and thank you for putting up this debate. My burning question is, I've read the advisory opinion of the Kenyan Supreme Court. Then I have in mind the fact that the East African Court of Justice Appellate Division as well has its own advisory opinion on the EACJ jurisdiction, the powers of the national courts vis-a-vis the EACJ, and what, and in that advisory opinion called the Charuhwenda case, the appellate division was very elaborate in the fact that it doesn't have appellate jurisdiction, as Professor Ssempebwa said, but it said it has powers to interpret, apply, and ensure adherence of the treaty. Then it said the national courts, whenever they are encountered with any question that involves the interpretation, application, or adherence of the treaty, then they have to refer it to the court, the EACJ. In fact, Charwenda opinion came out of a reference from the Uganda National Court. And surprisingly, the Attorney General of Kenya and all Attorney Generals of the East African partner states participated in giving arguments before the court came to the Charwenda opinion. I'm asking the panels and any members in the room, what happens to that opinion vis-a-vis the Kenyan one? Because EACJ seems to already have its own advisory opinion. Now, which opinion shall we be going with? Thank you.
Sorry. Thank you very much, Justin. Where did Michelle's hand go? Michelle, we were hoping that you'd begin to represent the 52% of our population, and we hear the voices of African women lawyers and non-lawyers on these issues. I'm looking for your hand, but in between, before I see it again, I see Emmanuel Sebijo. Emmanuel, you can take the floor. And I'm really encouraging African women lawyers and other activists and actors that are in the plenary that let your voice also be heard. Welcome, Emmanuel.
Thank you so much, Don, and thank you so much to the panelists and all the contributors. Yes, I just want to add my voice to the view that is disagreeing with this Cox interpretation or its adjudication of this matter. And I want to come from the perspective of international law. I think if it was the police that had arrested the applicant, Martha Karua, SC, and held her beyond the constitutionally allowed time, I think if the EACJ had held that Kenya had breached its obligations under the EAC Treaty, applying Article 6D or 7.2, there would not have been a very big problem. I think the big problem here is that it's because it is the decision of the Supreme Court of the courts of Kenya that are under the touch of the EACJ. And I think that is once again resolved in international law by the principle of attributability. The decisions of the courts of law are attributable to the state, just like the actions of the police or the actions of the army or of the legislature. And the EACJ recognized that it is not necessarily reviewing the jurisdiction of Kenya, the decisions of the Kenyan courts, but really holding the state of Kenya accountable for its breaches of the EACJ or the EAC Treaty. So the case was against the Attorney General of Kenya, not against the Supreme Court of Kenya, and it was regarding Kenya's obligations under the EAC Treaty and whether they were breached by the Kenyan courts and whether the decisions of the Kenyan courts amount to the actions or decisions of the state of Kenya. So I think the Supreme Court of Kenya is going on to try to defend its own jurisdiction, but really the case and the implications of the EACJ's jurisdiction is that we're looking at the actions of Kenya as a state. And someone also commented about at what level do the decisions of the national courts go to the East African Court of Justice, or at what level are they attributable? Whether magistrates' courts' decisions can also be challenged at the EACJ, and we're seeing a lot of this trend. For example, here in Uganda, we have a case going on about a bail application for murder, in a murder case, and someone has gone to the East African Court of Justice to challenge the High Court for not giving, not granting bail. Obviously, they're going to challenge Uganda. But should we be taking even High Court of Appeal decisions, or should we be waiting for the final decision of the court of that nation or of that partner state in order for us to attribute that decision to that state? It's a question that maybe I would want to hear some opinion from the panelists. But finally, we have Article 34, which Counsel Justice Ssempebwa has just referred to, the preliminary reference procedure. the treaty says that when a question concerning East African community law arises before a national court, it shall refer it to the East African Court of Justice. So I'm wondering why, when this question came up before the Supreme Court of Kenya regarding the applicability of the EACJ decisions when they concern judicial decisions of the domestic courts, that is clearly a question regarding East African community law. Why they did not refer it to the East African Court of Justice for a preliminary ruling? Perhaps this entire quarrel might have been avoided in a more diplomatic way. That would be my comment for now, Don. Thank you so much.
Thank you very much, Emmanuel, especially for raising that Article 34 issue. I'm really restraining myself here, knowing that my role is to be a moderator, not a panelist. So thank you for bringing it so that the panelists can deal with it. I'd like to turn it over back to the panelists now, and I still encourage colleagues in the room to either raise your hands to ask the question orally, or if you prefer, to put it in the Q&A or in chat. Is also being used quite liberally, as we should, in terms of cutting up the discussions that we're having. So I'd like to go back to the panel, and again, you're under no obligation to answer everything, but pick anything that suits you. Do we start with you, Prof, or do we start with you, Dr. Owiso?
Well, I have just a small comment on the appointment of judges of the East African Court of Justice. And this matter has been under discussion for a long time. What is happening, of course, is that most of the judges are seconded. They are judges in their jurisdiction. And a state is free to nominate either a High Court judge or a Court of Appeal judge to this court. And I agree with Huntington that there is a problem there, because at one time there was a justice of the first instance who was at home at a higher level than the president of the appellate court, which is something that shouldn't have happened. But the solution to this, of course, is to have an appointment system that is specific to the court, not to have judges seconded by the nation states, depending on whom they want, either to relieve some duties at the national level or to award, notwithstanding that his or her knowledge of East African law is lacking. So we have situations when a judge has got to learn in the first phase of the appointment. And then in the second phase is really when he or she takes on the responsibility. So there should be actually a judicial appointment system for this court. It's possible, as Huntington has said, that the Supreme Court was also conscious of the judges of the regional court who gave these decisions. And this is a matter of natural psychology. So who are these? These are children in the judicial system. They can't load it over us. So something has got to be done, but we've talked about this for a long time and nothing has been done. Moreover, initially, of course, there was little work at the regional level, but now the amount of work has increased and we need permanency at the regional court. And therefore, this also calls for a more transparent system of appointment. So to that extent, I agree with Hannington. Thank you.
Thank you, Prof. Over to you, Owiso, and then after that, we'll have you, Esther.
Thanks, Don. I've had quite a number of the questions thrown our way, generally. So maybe just to respond to some of them. Someone raised the issue of, and this has been raised by quite a number of people who've spoken, Articles 6 and 7 of the treaty. What do we make of the objectives and the principles stated therein? And so my quick response to this would be that principles and objectives, as generally stated in the preliminary sections of a treaty, are not by themselves, do not by themselves have specific legal obligations for states. States do not, you read those provisions and you cannot flesh out a specific obligation of a state from a mere statement of principles and objectives. For you to then hold a state accountable for something, you'd have to go to the more substantive provisions of that treaty, where the treaty states specific obligations, what a state has to do and what it should not do. So for instance, you will then go into, if it's a human rights treaty, for instance, you then go deep and find a particular provision that fleshes out the right to a fair trial and what it entails. This is what a right to a fair trial says, or blah, 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 all that. So in that particular respect, you can then hold a state accountable to specific legal obligations in that substantive provision. But general provisions on objectives, stating the general objectives of the treaty and the principles undergirding that treaty, to my mind, are not provisions that have specific legal obligations that you can hold states to. And I think I believe firmly that this is where the rain started beating the East African Court of Justice, when the East African Court of Justice arrogated to itself jurisdiction by simply making reference to Article 6 and 7 on principles and objectives. Those principles and objectives do not have a specific obligation of the state that you can flesh out and say has been violated. So the East African Court of Justice, specifically, I believe it started with the Katabazi case, where the court said that, sort of discerned specific legal obligations of a state from the principles and objectives from Article 6 and Article 7. And I do firmly believe that that was a wrong interpretation of the EAC Treaty. And of course, the EACJ has insisted on this particular interpretation since Katabazi. We have quite a number of cases thereafter that the court has adopted or continued to reiterated that particular interpretation. And as I said earlier, at the beginning of this conversation, just because you keep repeating something as a judicial institution, just because you keep repeating a particular position, does not necessarily make it correct. So because there's a body of jurisprudence being built by the EACJ on the question of Article 6 and 7, doesn't necessarily mean that the initial original sin, as I would call it, was correct, right? Then, so similarly, because I believe Ochel Dudley threw something my way and asked, why do I believe that the EACJ is usurping jurisdiction? First, what I've just referred to in its interpretation of Article 6 and 7, interpreting principles and general objectives as a source of binding legal obligations. I believe that was when the rain started beating us. And secondly, the court's interpretation of Article 30, paragraph 1 of the EAC Treaty is problematic. If you go back to the BAT case, and what the EACJ said in that particular case is, if you permit me, I pull up Article 33, 31. So if you permit me, I'll just read it. Subject to the provisions of Article 27, any person who is resident in a partner state may refer to the determination by the court, the legality of any act, regulation, directive, decision, or act of a partner state or an institution of the community on the grounds that such act, regulation, directive, decision, or action is unlawful or is an infringement of the provisions of the treaty. What the court's interpretation, the BSD case of this particular provision, was that the EACJ would have jurisdiction to review, so to speak, I use the word review loosely, to review any decision or act of the state if it is considered to be unlawful. And that particular part, the court interpreted to mean that the unlawfulness does not only relate to the EAC Treaty, but it's unlawfulness in the general sense, meaning that the court then has jurisdiction to review anything done by the state or any state organ, as long as it's unlawful. That means that the court then has jurisdiction to, merit jurisdiction to look at national laws, national judgments, irrespective of whether they have anything to do with the interpretation of the EACJ Treaty. And I believe that that was a very wrong interpretation of that, of the court's jurisdiction, because the first part of that provision makes it subject to the provisions of Article 27. And Article 27 is quite express that the court's jurisdiction is over interpretation and application of the treaty. Therefore, in the process of looking at, of doing a merit review of act of the state, of any partner states, the unlawfulness has to relate to the interpretation and application of this treaty. Then my conclusion then is that yes, the EACJ has merit review jurisdiction. I use that loosely because my friend Nyanje doesn't like that term and I see him in the audience. So my interpretation then is that the EACJ has merit review jurisdiction over national laws and acts of the state. And acts of the state here includes judgment of judicial bodies, domestic judicial bodies, because principle of unity of the state. So the EACJ has jurisdiction to review those national laws and domestic judgments, but only in as far as what is being reviewed has an impact or has something to do with the interpretation and application of the EACJ Treaty. So in that respect, I do firmly believe that the EACJ was wrong in the BAT case, and it has continued with this particular interpretation, and that to me is a bit of a usurpation of powers. Similarly, the Supreme Court of the Republic of Kenya is also wrong, because the Supreme Court interprets Articles 27, Articles 23, 27, and 33 of the EACJ Treaty to mean that the EACJ does not have any form of merit review jurisdiction over national laws and national judgments. And that is also wrong, because as I've indicated, a proper interpretation of all these provisions is that the EACJ would have merit review jurisdiction over national laws and domestic judgments in as far as and only to the extent that they relate to the EACJ Treaty. So in that respect, I believe that both courts were wrong. And this is, again, I go back to what I said earlier. It is this misapprehension of jurisdiction that is causing unnecessary friction between the EACJ and domestic courts. And I'm afraid to say that this is it's not the last we've seen of this. We are still going to see domestic courts, especially apex domestic courts, trying to push back as against the EACJ on particular issues, especially the question of Article 31. We are still going to see more pushback. And I think it's a very unfortunate situation, because this is totally unnecessary if the EACJ appreciates the limits of its own jurisdiction, and if domestic courts themselves appreciate the extent of the EACJ's jurisdiction. And then lastly, somebody mentioned Article 34, and I'll just conclude my comments there. Article 34 of the treaty. Yes, I believe a prudent approach to, when we have an international court that possibly has concurrent jurisdiction with national courts, I believe that a prudent approach would be Article 34, where a domestic court then makes a reference to the EACJ. But we have to remember also that Article 34 gives domestic courts an option to either do this or not. It says shall, if that court considers a ruling to be necessary to enable it to give judgment. So this calls on, this goes back to the question of judicial humility. If domestic courts have the sort of judicial humility to acknowledge that, well, we are limited to the extent in this particular regard, we are limited in what we can say because of probably lack of EAC law expertise. Let's refer this to the EACJ, and then with that ruling, we can be able to issue judgment. But this is not going to happen as long as we have an international court, the EACJ, and domestic courts perceiving each other to be at war. That is not going to happen. So ideally, in this advisory opinion before the Supreme Court of the Republic of Kenya, it would have been an idea, actually, for the Supreme Court to send this to the EACJ for a preliminary ruling on particular questions. Then using that, then the Supreme Court would have come to a proper conclusion. But we have a Supreme Court that is not humble at all, even internally, not even as against the EACJ. Even internally, the Supreme Court is not very humble, so to speak. I don't like that particular term, but they do not acknowledge when they have made a mistake. So if we don't see them doing that as regards domestic matters that are purely domestic in nature, then I don't quite expect that they would do that as vis-a-vis the EACJ, though Article 34 is actually quite fundamental. And then finally, because we do have, I'm yet to actually come across any commentator, lawyers, and everybody else who's interacted with that advisory opinion who agrees with it entirely. We all agree, at least. We disagree and agree on particular issues, but at least the one thing we have common ground on is that that advisory opinion is lacking in one respect or the other. So my proposal then, and I've discussed this with quite a few people, is why don't we ask the Supreme Court of the Republic of Kenya to review that advisory opinion? Because as it is, it's a bit of a travesty. Even if they come to the same conclusion anyway at the end, we would at least benefit from a coherent reasoning. So my proposal is, yes, as much as, or as while we can consistently criticize and critique the advisory opinion, it is possible for us to actually ask for a review of this particular advisory opinion from the Supreme Court. And then similarly, if we can convince one or two partner states, I don't see anything that stops one partner state from actually going to the EACJ and asking them what they think about this, in the form of asking for an advisory opinion from the EACJ. Otherwise, we will still have a back and forth on this particular question. And as I said, sorry to be a bit of a doomsday person, but I don't think this is the end of the matter as between the EACJ and domestic courts. Back to you, Don. I hope I responded at least to a reasonable extent to most of the questions. Don?
Okay, I think Don is still trying to log on to the platform. Let me recognize the presence in the plenary of Honorable Lady Justice Anita Mugenyi, Judge of the Appellate Division of the EACJ. We also have Lady Justice Catherine Pamugemereire, Judge of the Supreme Court of Uganda. Of course, apologies for any other dignitary that we may have overlooked. I now want to invite Ms. Esther Muigai-Mnaro to make comments.
Thank you. I'll try and keep it very brief. First, I have not heard from my fellow panelists any of the cases that Ochiel asked him to name where the EACJ has actually usurped its jurisdiction. If anything, the EACJ has tried very much to ensure that it is limiting its jurisdiction only to interpretation of the treaty, even where we know for a fact that they could go beyond that. So I would say, just like Huntington said, they are actually underusing the mandate that they have. And if we were to look at the particular case that is the subject of this advisory opinion, what the AG of Kenya has done is that he has gone to the Supreme Court and actually asked the Supreme Court to sit as an appellate division of the EACJ. And why am I saying this? The issues that he has raised in the advisory are issues that were raised in the first instance division of the court, raised in the appellate division of the EACJ, answered very conclusively by the EACJ in both instances. And then the AG took the same issues to the Supreme Court of Kenya and asked the Supreme Court to make an advisory reference on the same. So if you were to look at between the EACJ and the Supreme Court, who is asking the other to sit as a review or an appellate court, we know which court is acting as an appellate, and that is the Supreme Court of Kenya. The reason I'm saying this is when we went to the EACJ, we were asking them very simple question. We were asking them, look at what the decision of the Supreme Court has been. is it in line with the provisions of the EAC Treaty? And they made a decision on that. And for them to make that decision, they had to interrogate into what was the municipal acts and laws of Kenya. So when we say that there was assumption of powers, I don't see any. The decision that was made by the EACJ was strictly in line with the EAC Treaty and strictly within the provisions of Article 23, 27, 30, and of the EAC Treaty. And to a larger extent, by the operational principles of 6D and 7.2 respectively. So I would say it is very unfortunate that we are turning politics into a game when it comes to the EACJ, whereas a lot of people, what they forget is that at any given time, it could be those who are in power now could be the ones that come before the EACJ tomorrow. So if we cripple it today, where will you run to tomorrow? I think I'll end it there.
Dr. Owiso?
Edmund, yeah, if I may just clarify something. I mean, I did not, just to be clear, when I argued that the EACJ is sort of usurping the authority of domestic courts, I wasn't making specific reference to the Martha Karua case. No, that was actually not what I was referring to. That is why I did not make reference to that case. Instead, I made reference to the Katabazi case as an example, and the BAT matter as an example. I deliberately avoided making specific reference to the Martha Karua case. For many other reasons, part of it being that I believe that to some extent both courts were wrong, and I've said as much. So this was not in reference specifically to the Martha Karua case, but I still do firmly believe that in two particular respects. First, how the EACJ has interpreted Articles 6 and 7 to mean that they have specific legal obligations for states. I believe that that's where the rain started beating the EACJ as a general question. And similarly, how the court has interpreted Article 31, specifically in the BAT case, that also, I believe, is typically a usurpation of jurisdiction of domestic court. So this was not in specific reference to the Martha Karua case. And on that note, I think it's important to emphasize, because where I'm going with all this is the question of jurisdiction. And I think it's important to emphasize that in negotiating and concluding treaties, the states, generally defer to the bare minimum concept, where they achieve, we end up with ambiguously drafted provisions of the law of the treaties in order to get what they want. However, one of the very few things in treaty negotiation and drafting is that states are often very particular about jurisdiction. So jurisdictional clauses end up being one of the few that are ordinarily drafted in such a way that they leave very little, if any, room for ambiguity between states. Because states are very, very particular about jurisdiction because of the implications it has, not only for sovereignty questions, but also for the general political atmosphere. So we therefore need to read jurisdictional clauses with as much keenness and care as possible, because of that particular impact that it may have on states and on the decisions of the court. So really, I'm not making specific reference to the Martha Karua case, but this was just in a general sense, my assessment of where the EACJ is going with this. And I was using that to lay the general context of how we end up again with the EACJ and the Supreme Court of Kenya appearing to be fighting each other unnecessarily.
Okay, thank you, Dr. Owiso. Let me bring in Professor Frederick Ssempebwa to try and make his comments on the questions that have been raised.
Well, I have little to say. I think one of the questions was whether the regional court is issuing academic decisions which do not assist us. I would say that the regional court has been quite useful for our integration process. What has been lacking, of course, is not a fault of the of the regional court, what has been lacking is jurisprudence on economic integration. Much of the jurisprudence revolves around human rights, but this is a matter that is due to us lawyers to push more and more of the disputes that involves trade matters before this court. But the jurisprudence has been useful, and since the court ruled that it could award damages or compensation, this is going to provide the means of having its decisions bite instead of just making declaratory orders. So I believe that we lawyers have something to do with what goes before the EACJ, and we should assist the court to concentrate on the core of its jurisdiction rather than the human rights. Of course, is important, because if you have rogue states, you cannot have successful integration. Then I would like to also to end by saying that what we are discussing is really the attitude of states. It's not the court as such, because the states themselves have this attitude of reluctance to cede any sovereignty to a regional structure that they have created and intended to have regional powers functions. This is not exemplified at the judicial level alone, but also in the other trade interactions where we still have reluctance of the states to obey community law. Now and again, they impose non-tariff barriers, they close borders, they engage in quarrels which we don't know about. And this is against the treaty that they have signed. So we should be quite aware of this attitude. And when the Supreme Court of Kenya issues this advisory, they know very well whom they are trying to please. It is the state of Kenya. If the state of Kenya was well posed to ceding some sovereignty to the regional structures, then this shouldn't happen. So let's not be oblivious to this, the paramount problems that we face and we have always faced. And we should continue to agitate that the states should obey community law. I'm not saying that the issue of jurisdictions of the regional versus the national courts is not important, but the overall problem is exactly that. So this is what I wanted to emphasize. Thank you.
Thank you so much, Professor. There are two questions on the Q&A section. I will just read the questions and then ask Mnaro to respond to one of them, and then Dr. Owiso to the other. Thereafter, we will be making our concluding remarks in the interest of time. The first question is by Frederick Kadima. He says, will the Supreme Court of Kenya and other domestic courts in the region accept a decision from the EACJ? For instance, declaring actions of a domestic court null based on the principles and objects of the EAC Treaty. That is directed to Mnaro, and then The last question is by Abel Nabutola. He says, what mischief was the SCOC trying to address in the advisory opinion? Were Kenyan litigants looking at the EACJ as the fourth appellate court after the Supreme Court, or was the opinion a floodgate argument of the Mother Karua, the Mike Song, and now the SC Ahmed Nasir cases? That can go to Dr. Owiso. Thereafter, we will begin making our concluding remarks. Let's start with Esther. Esther Muigai.
Edmond, sorry, I don't think I got the question well. You said it's in the chat. Let me first look at it.
Okay, as you look at it, Dr. Owiso, maybe you can respond to the second.
Well, that's a very difficult question to respond to, Edmond, because even I do not know where the Supreme Court of the Republic of Kenya was going with this, with the advisory opinion. It's not clear to me either. First, because how did they even get, domestically speaking, even reading Article 163 of the Constitution on jurisdiction, on advisory opinion jurisdiction, and the Supreme Court even fumbled with its own jurisdiction to issue that advisory opinion. So it's not quite clear to me where they were going with this or why they were going with it, at least legally speaking. But politically speaking, of course, it was a direct response to the Martha Karua cases that ended up at the EACJ. So that was more of a political response than a legal response. And of course, the apprehension that, that would then, of course, open floodgates, because we've also seen other potential cases such as the Sonko case and, Ahmed Nasir Senior Counsel coming up recently on this particular question. So to me, my response would be that it's difficult for me to see where they were going with this, what mischief they were trying to avoid, at least the legal mischief that they were trying to plug by this advisory opinion. But of course, the political mischief is quite clear. But whichever the case, whether there was legal mischief or political mischief, whatever they were trying to do, I am firmly of the opinion that they did not do it well. At least they fumbled and they did a terrible job at it. Because why I say that is, I may disagree, you and I may disagree with whether or not the advisory opinion was necessary, but at least we would be having quite a different conversation today if the advisory opinion was well drafted, if it gave us proper reasoning as to the conclusions that the court arrived at there, if we would read it and see proper reasoning leading to the conclusions, if we would read it and see coherence in argumentation, if we would read it and see internal consistency in the argumentation. If we had an advisory opinion of that nature, of that status, then we may disagree probably with the conclusions or not even agree on why it was necessary, but at least we would be able to appreciate the reasoning behind them and where the court was going with this, even if we disagree. But we've been denied the benefit of that, because that advisory opinion, as I keep insisting, at least to me, is pretty inconsistent, incoherent, and difficult to follow. And that is why I go back to what I said earlier, that there's still an opportunity for us here to move the Supreme Court to review that particular decision with everything else that has come up in the conversations in mind, as to whether the Supreme Court will be humble enough to undertake a review of its own advisory opinion. That's an open question, but I think that would be my response to that question. I hope I've done it justice.
Thank you, Dr. Owiso. Mr. Muigai, it's your time.
Thank you, Edmond. To answer the question, I would say first, it's not a matter of whether any could accept or not accept. And I would not the decision is now based on the principles and objects of the tool. I've interrogated that decision and pointed out which part exactly are in violation of the EAC Treaty. And just because a decision made by a domestic court, it doesn't matter how many times or consistently it has been made, as long as at the end of the day it is in violation of the treaty. That's the position. If it goes before the EACJ, it's in violation of the treaty. So whether the court back in the state decides to accept the decision or not, is another case. It's up to the state to decide if they want to comply or not to comply. And it's unfortunate that when it comes to implementation, there's only so much you can do after you've litigated a case. But so does it mean then that we'll stop taking cases that challenge or ask the EACJ to look into decisions of national courts just because the courts back home will not accept it? I don't think so. So I would say, if it's against the treaty, then it will be ruled as such, and it is up to the state then to decide what to do with that decision.
Thank you so much, Ms. Esther Muigai. There are a number of questions, but I think in the interest of time, we may want to continue with this conversation on our various platforms. And for those who have raised questions, we want to thank you so much. We will be looking at these questions and probably sending them through to our panelists later on. For now, we will want to now jump into the concluding remarks. We will want to start with Professor, and then Dr. Owiso, you make your concluding remarks, and then we'll finish with Esther Mnaro, and then thereafter we'll be coming to the end of the webinar. Welcome, Professor Frederick.
Yes, I want to conclude by saying that there are a number of sweeping statements made in this opinion. And if they remain as such, many national courts would feel that the East African Court of Justice is subservient, its jurisdiction is subservient to that of national courts. That's one of the statements which is made. It's very troubling when you look at these several statements. And where I agree with Dr. Owiso is that probably it would be useful to have this decision, an application to review. I doubt whether the Supreme Court would entertain that application. But these are very, very sweeping statements, very misleading statements. And from now on, I very much doubt whether any decision made by the East African Court of Justice that has some question over judgment of the National Court of Kenya, even if it involves interpretation of the Constitution. I doubt whether that will be respected, because this is an apex court, and any court will say we disregard the decision of the East African Court of Justice, which is very, very unfortunate. But more than that, well, you know, the national courts of other partner states could well follow and hold the same view. I have clients who have cases before the East African Court of Justice against Kenya, and they have raised this question whether they should proceed with their litigation before this court or stop, because they fear that it will come to nothing if a decision is made by the Arusha court. The Kenya state might not respect it if on the same matter there was a decision of a national court. And this has been distinct before, because the Arusha court has exclusive jurisdiction over interpretation of the treaty, but these jurisdictions now may not matter much. Thank you very much. I want to give others a chance to wind up.
Dr. Owiso, you can come in. I can see Don Dare is back. Don, we are making concluding remarks, and we are now on Dr. Owiso.
Thank you, Edmund. Nice to see you again, Don. Though you have commandeered somebody else's account, we can see that, Don. But just as a way of concluding, I have to. I'm a big proponent of the East African Court of Justice. I like that court for the potential that it holds to farm up our integration. I mean, I'm a national of two EAC partner states, so I'm very invested at a personal level, and of course, as a lawyer, in the success of this of this court. But there's a tendency amongst lawyers, international lawyers mostly. We have this rather, and I make this as a general statement, we have this rather strange and paradoxical belief that international courts are infallible, that they are necessarily always right, that they are never wrong. And I think we need to disabuse ourselves of this particular idea, because international courts, much like domestic courts, such as the Supreme Court of the Republic of Kenya, are often quite wrong about many things. They're perhaps even as wrong as many times as they are right. So that then, brings me to my concluding statement that in trying to understand and push forward a proper and a well-functioning and effective and respected East African Court of Justice, we have to be very clear about its relationship with domestic courts. And this then, of course, goes back, again, as I keep emphasizing, goes back to the question of jurisdiction, because this has significant political implications and legal implications as well. But because I mentioned political implications, I think I need to ensure that I'm not misunderstood. I need to be very clear on what I mean by political implications. I'm not saying that the East African Court or any other international court should make its decisions based on the politics of the day or based on the politics of the East African community. That's not what I'm advocating for here. Quite the contrary. What I mean is that the EAC Treaty's jurisdictional provisions, that is Articles 23, 27, 30, and 31, are very specific and express on the nature, the scope, and the limits of the jurisdiction of the EACJ. It is therefore in the best interest of not just the East African Court of Justice, but of domestic courts and of all citizens of the EAC, for the EAC itself to limit itself to the precise confines and parameters, the scope of its jurisdiction as expressly, delimited in the EAC Treaty. This is not a restrictive interpretation of the treaty's, jurisdictional provisions. Rather, to my mind at least, it's a proper interpretation of the court's jurisdiction. There is a distinction between restrictive interpretation and the proper interpretation of jurisdiction. Restrictive then would mean that a court, where a court has jurisdiction clearly and expressly stated in its constitutive instruments of a particular matter, but it nonetheless hesitates to exercise that jurisdiction because of probably extraneous political factors or consequences that may arise therefrom. That is a restrictive interpretation of a court's jurisdiction, and that is absolutely something I do not get behind. That is something I absolutely do not support. This is, but the difference then would be with what I'm advocating for is not a restrictive interpretation of jurisdiction. What I'm advocating for is a proper understanding and appreciation by both the East African Court of Justice and domestic courts, including the Supreme Court of the Republic of Kenya, of the nature, the scope, and the extent, and of course the limits of the jurisdiction of both the EACJ, as expressed in the EAC Treaty, and of domestic courts, the respective jurisdictions of these courts. And then with that appreciation, the EACJ should then be able to exercise its jurisdiction to the fullest extent permissible by the treaty, nothing less and nothing more. So if both courts were to understand, both levels of the judiciary were to understand and appreciate their jurisdictions, we would not have this particular situation that we have today, and which is not likely to abate anytime soon. And if that were to be understood, then I see a future for the East African Court of Justice, a harmonious working future for the East African Court of Justice. We aspire as the EAC community to a political federation, or whatever you call it, federation. I'm skeptical about it, but if we are to get there, the EACJ should be the one to lead us there, to shape the law so that the politics follows it. But it can only do that if it appreciates the nature, the limits, and the extent of its jurisdiction. I conclude with that, Don. Thank you. And
thank you. And over to you, Shiro. Sorry, you're still muted.
Can you hear me now?
Yes, yes, we can.
Okay, thank you, Don. It's good to see that you're back. I hope you've worked in and you will not be left by the plane as you attend the webinar. So I'll keep it very brief. I think it's very important for us to remember that the EACJ has made a lot of steps from the days of Anyang Nyong'o in terms of jurisprudence, in terms of growth. And it is important to note that the matters that are now coming before the EACJ are no longer just human rights matters. You know, it's no longer just about issues that touch on very common things like it's my right to access to justice or fair trial. No, it is important to note that if we cripple this, we are also crippling a chance for the citizens to take other issues such as commercial matters that are already coming before the court. It is important for the states to remember that even as they are doing this, states are not suing each other before the EACJ. So if we cripple it, if it is Kenya's turn to come before the EACJ and they have cut its legs and they want to sue, for instance, Rwanda or Uganda, where will they go? Will they now again start rewriting the rules or giving a different advisory opinion? I think I differ with my learned colleague a bit on the issue of jurisdiction. I do not believe that there's a jurisdiction question that the EACJ does not understand where its jurisdiction lies. I don't believe so. I believe it is the national courts that are feeling like they need to show that who is the king here or who is the queen here, because we are feminists. Who is the king or who is the queen here? The EACJ has so many times turned away matters based on the issue of jurisdiction and said, look, on this one, we don't have jurisdiction. You go back. But when it came to a chance for the Kenyan Supreme Court to say, even as when it comes to interpretation of the EAC, we don't have jurisdiction, let's go back to the EACJ. They didn't do that. So on this one, it's very clear on who is flexing muscles. And I hope that this setback does not stop the many cases that people have been filing at the EACJ, because the more precedents that are set, the more cases that are had, the court will grow. And even on the issue of implementation, which is a big issue and which is a big discouragement to a lot of the litigants, it's just a matter of time. We will get there. Thank you, Don.
Thank you very much, Shiro. I'm just trying to check whether Edmond or Professor Mbani has any final words, but even as we do that, it is not too late to recognize those who my eyes have just seen. My eyes have just seen, and I recognize the presence among us of the Honorable Mr. Justice Cheborion Barishaki, Judge of the Appellate Division of EACJ, and actually Secretary General Emeritus of the East African Law Society. I also recognize the presence of the very admirable Honorable Lady Justice Monica Mugenyi, Judge of the Supreme Court of Uganda, and Principal Judge Emeritus of the East African Court of Justice, First Instance Division. Apologies for anybody. We've gone over time, so I'll just rush to thank all who have stayed with us till now, and all the contributions that have been made already. The debate continues. We also really like to thank our partners, Kabrak Law, who have hosted this. As they indicated to us very clearly at the beginning, this is Jumuiya 4. This is LA. And I think the issues that have been raised have clearly set the agenda for at least 3 other Jumuiyas, Jumuiya 5, 6, and 7. And I can suggest that, first, to agree with Dr. Owiso Owiso, I agree that all courts, like all human endeavors, are fallible. So as a public international lawyer myself, I agree with Owiso and I'm in his camp that there's no human endeavor that's infallible. And where even international courts may make mistakes, we point them out. It's not out of malice, but it's out of making the future better than the past. But in terms of Jumuiya 5, 6, and 7, I suggest some of the things we can discuss is this. I know for a fact that colleagues are dealing with similar questions at other regional courts, at other courts of regional economic communities, regional mechanisms, and also at the continental level. So maybe in a follow-up one, we can engage with our colleagues, for instance, from the Community Court of Justice or the Economic Community of West African States, or in short, ECOWAS CCJ, to see how they're dealing with this. And on a similar light, maybe in a future one, much as our focus is a Jumuiya, we could see how the African Court on Human and People's Rights has dealt with these questions, because it has, and what the reception is, and what are the lessons learned. And one other thing that I think has been raised a lot by a number of presenters here, or a number of speakers, interveners, is the mode and method of appointment of judges to our beloved East African Court of Justice. And perhaps it is time as a community, we have one Jumuiya on just that. We do appreciate that part of the matters are in court, but we're very able to circumscribe around our approaches to sub judice and still be able to have this discussion. So thank you very much, everyone. I think this just means that with the help of our colleagues at Kabarak Law, and of course the team at PALU and others, we will continue with these conversations. Do have a lovely evening.
Thank you so much, my co-moderator, Dawn. Before we pray, I just want to mention that now we have come to the end of this very insightful webinar. And again, thank you so much all for sparing your time to attend these discussions and enriching them with your questions and comments. Again, I want to thank PALU, Don Dea, and your group for collaborating with us. Before I end, I will want to remind us that Jumuiya, the East African Community Law Journal, is a global journal bringing in scholars of EAC law and policy from across the region and from various universities and institutions. We have a board of advisors, or the advisory board, that consists of a number of individuals, including Justice Charles Mkandawire, Mr. Guy Sowe, Professor Louis Franceschi, Professor James Gabi, Honorable Nyambua Mbatia, and many others. I would, at that point, want to remind us that we are still receiving and accepting commentaries and articles, both to our journal and to our Usuli blog. Now I will welcome Sylvia Nyanchama to pray for us. Thank you so much.
Let us pray. Our gracious and merciful Father in heaven, dear Lord, we are thankful for the success of this webinar. We do pray that whatever we have discussed, may we take it into action, and we pray for the betterment of Jumuiya. May you bless all the panelists and all the people that were able to attend this webinar. It is my humble prayer in Jesus' name. Amen. Thank you all.
Thank you.
All right. Goodbye, everyone. Have a good evening.
Goodbye.